Hello, everybody. Today we'll be dealing about what is IPR and overview of copyright. Hi, my name is Tripti Bhushan. I am Assistant Professor of Law. So let's start. We'll see actually what is IPR. IPR generally stands for Intellectual Property Rights. We all know that in present times, intellect is an integral part of one's own personality. And intellect plays a very crucial role in deciding what sort of labor our body is engaged for and what sort of work our hands can take up. We all know that out of all the animals, only human beings have the capacity to create any sort of property or something new by using our own intellect. Thus, any property created by human beings can be said as intellectual property. In the current image, you can see that intellectual property rights. So this is a brain, right? So whatever we are thinking in our mind and we are actually implementing that. So that comes as property. So once a property has been implemented, who will have the right upon that property? Of course, we will have the right on that property because it's our own property. Now we'll talk about what are the types of property. Property are generally two types, movable or immovable property, tangible or physical property or intangible property. Now, immovable properties are those properties that cannot be moved from one place to another, like your house. Your house cannot be moved from one place to another. You can shift your house by changing the location of your residence, but you cannot permanently change your house. In the same way, if we talk about movable property, so movable property is any sort of property that can be shifted from one place to another. Suppose this person is standing over here, he could simply move to this place by walking. If he is holding any sort of book or I am having any sort of book, I picked up from my desk. Now I can keep it to some other place. So the book is a movable property, right? Now, if we talk about physical property and intangible property. Now, what is this all about? Physical property is something that we can touch and feel by our bodily senses, like a car. In my house, I have Apache bike. I have a Mercedes Benz. So every morning I'm in love with the car, right? Every morning I can get up, I can touch the car, I can feel it. So this is a physical property which you can touch it, which you can sense it, which you can feel it. But in case of intangible property, we cannot touch the property, right? Suppose in a live concert, a person is singing a song. So can you imagine? Can you actually feel the song? Can you actually touch the words? No. They cannot touch the words. We could actually listen to the voice, to the music, what the person is singing, but we cannot touch it by our own hand. Right. So now moving ahead, this was all about the types of property. Now actually let us see what actually IPR means. As we have discussed earlier in the intro part, intellectual property rights basically is the right that arises from human conduct. It is a creation of mind, so we call that as intellectual property. So we have discussed earlier that intellectual property rights are those rights that arises from human conduct. You know, when a person is creating something, the law gives him or her the right to protect their own property so that the third person cannot misuse of it. Right. Now, moving ahead, we will see what are the various types of IPR. Nowadays, we have patent, trade secrets, trademark, copyright, GI, and plant varieties. These are various sorts of IPR. IPR is never single. IPR are many, they have all different strata to work on. The concept of PETA works on different things. Trademark works on different things. Copyright works on different things. Trade secret, GI, and same way for plant variety. So we'll have a quick description about what all those properties actually are. Now moving ahead, we'll see that brief about every IP right. Now let's talk about patent. What does this word mean? Patent. Patent law revolves around the concept of novelty and inventive steps. Now, actually, if we look about the patent, patent is an exclusive right which is granted for any sort of invention that a person he or she does. In the case of patent, the patent owner may give permission to do something or to license the other parties to use the invention on mutually agreed terms. In the case of patent, what happened? The patent owner who has created any sort of invention, new invention, first of all, the invention which he or she has done has to have the inventive step and novelty. What does this inventive step mean? And novelty. Inventive step means that something new, something additional onto the prior existing thing. You have to have a modified version of the thing you actually have to get it patented. Now, it is the right of the patent owner. If he wants, he can give permission to third party to use his or her patented invention for a limited period of time only on mutually agreed terms. If both the parties are ready to go for agreement, then licensing can be done. The owner may also, even sell the rights to the invention to somebody else, who will then become the new owner of the patent. Suppose I have invented a machine. Now, out of my willingness, I want to license it to some third party, to some XYZ person. I can give my right to use the invention to the third party. So once I have given that permission, that right to use my patented invention to the third party XYZ, that XYZ will become the new owner of the patent. Right. Now, the question comes to a mind that what sort of invention can actually be protected? What are the various sort of inventions that we can already that we can actually protect by using patent? So let's look. Patent may be granted for any invention in the field of technology, from on everyday kitchen utensils to a nanotechnology. An invention can be a product such as even a chemical compound or process or any drug or medicine. So we know that anything that you have created can be patented because patent has a very usage in everyone's life. Even a single utensil in your kitchen may be a big technology, maybe a drug, maybe a medicine. Now, what does a term actually comes in the use of patent is utility. What does actually utility means? Utility means that whatever you are inventing, whatever you're creating has to have some sort of usefulness in the eyes of law and for the public. Suppose if you're inventing or if you're discovering a medicine or a drug, that should not be only limited to your personal use. That should always be useful for the public at large. Else, you won't get patent. But if your invention is already useful for a very small portion of people, then also you'll get a patent. Now, how long does a patent protection last? We must be thinking if we get a patent, right? If we are inventing something, obviously there has to be some duration. For how many years the patent lasts? Generally, the patent lasts for 20 years from the filing of the date of application. For taking patent, you have to file an application in the National Patent Office. Now, how does this patent right are enforced? How can we actually enforce these patent rights? So, the patent rights are usually, enforced in a court of by initiation of the right of the owner. A person who want to get the patent has to take a step. Nobody else can take a step on this behalf. In most of the code, law, they have the authority to stop patent infringement, but the main responsibility lies only with the patent owner. If you are thinking that somebody is trying to infringe your patent right, it's only you. You have to monitor. You are responsible for your own thing. But in some case, court can also protect it. Now, the very important thing revolves around the patent is licensing. What does licensing of a patent mean? So if we look after licensing, as we have discussed earlier, it's a sort of permission to use to do a particular thing given by the actual owner. So here, licensing of a patent simply means that the patent owner grants permission to another individual or any sort of organization to make use or sell his or her potential patented invented, right? Whatever invention you have made, you have a right to give it to make a use to third party. But this will only take place according to the agreed terms and condition. Example, there has to be certain fees that needs to be paid by the licensee to the licensor for a definite purpose of time. Now what is the term licensee and licensor? If we talk about licensee, is a person to whom the licensor is granting the right of patent. Suppose I have invented a computer machine, right? I have the patent on it. I have applied to get the patent by fulfilling all the necessary conditions and criteria for that. Now it's my choice. I can give it to XYZ person. So to whom I will license my patent will be the licensee, and I will be the licensor. So now if I'm giving my invention to somebody else, obviously I won't give it in free, right? I want some sort of remuneration, right? I want some sort of monetary incentive. Same goes with the patent also. So once the licensor is allowing or giving permission to the licensee to use his patented invention, they have to pay certain amount of fees decided by on agreed mutual conditions. They both will sit, they both will have a discussion, they both will fix a fees that has to be paid by licensee, and then the licensee can make use of that patented invention. Now, what are the basically essential criteria for getting patent? Now, we have discussed earlier that novelty, inventive step, and utility. These are the three main criteria that has to be fulfilled for getting patent. Now, who grants actually patent? You must be thinking. So it is generally granted by a national patent office or a regional office. Remember this, patent is generally granted by national patent office or by regional office. Now, what are the patentable inventions? Now you must be thinking, what sort of things can be patented? As we have discussed, from utensil to a nanotechnology, everything is patentable, right? Depending on the criteria and conditions, if you are matching to it. Now, to be patentable, an invention must be a new, we have discussed. It should also, include any inventive step and be capable of industrial application. Means that it should not be simple. It should be something new, something modified. And utility plays a very important role. So whatever patent, if you want to have a patent on your invention, in some way it should have usefulness. Suppose that is only useful to a small portion of society or even to a single person, then also you are eligible for patent. Now moving ahead, we'll discuss about what are trademark. Trademark is one of the most important essentials of IPR in today's life. It is based on the concept of distinctiveness and similarity of marks and goods. Suppose, I'll give you a very simple example. In a class exam, there's a paper of maths. There are two people, X and Y. One scored 90, right? One scored 89. Almost they both have passed. They have, similar handwriting. So a teacher it's very difficult for a teacher to judge. Suppose in that copy, if your name is not mentioned, but you have similar sort of handwriting, a teacher might get confused. Whose copy is whose? Whether it is X copy or Y copy. So there has to be some sort of distinctiveness. So trademark actually, what does trademark do? Trademark actually is capable of distinguishing the goods or services of even one enterprise from those of another. One can actually protect the trademark through registration by simply filing an application for registration with some national or regional trademark office. What does trademark do? Trademark helps you to distinguish, to differentiate between two similar goods or services of one person from another, so that there should be no misconception, no defectiveness between the amount of goods and services of one another. Else, this would try to create likelihood of confusion in the minds of people. Now we have to remember that trademark can be filed simply by registering with the national or regional trademark office and by paying the required fees. For everything you have to pay the fees. If you haven't paid the fees or if you haven't filled the form correctly for registering the trademark, you won't get any sort of registration. And even at international level also, you have two options. Either you can file a trademark application with trademark office of each country in which you are seeking protection, or even you can go for a WIPO Madrid system that actually look after the trademark registration. And now you must be thinking, as we have discussed in the case of patent is granted for 20 years. Now, trademark is given for 10 years. Right. It can be renewed by paying additional fees. Suppose now your term is over. Registration, you have done your registration of a trademark, but it has over. Now you want some extended additional year. You know, now you can pay some additional fees. Now I'll give you a very simple example. Everybody in like nowadays we have antivirus, right, in our laptops or PCs. Now it has a duration, minimum amount of duration, that is 1 year, 2 years, 6 months. So suppose now we have paid for 1 year antivirus. Now it has expired. Now we want some more, extended year. We want antivirus to last for like next 2 years. Now what we can do? We have two options. We have to pay the fees extra. We have to get it renewed. So by paying a small amount of fees, our protection can be renewed, right? Now, what is the benefit of trademark? Why we should register a trademark? So let us discuss. Like trademark has certain benefits when it is registered. So when the trademark is registered, then the trademark owner will have exclusive right, to use the registered trademark. This means that trademark can only be used by its own owner or licensed to another party only by him. Registration provides legal certainty to the trademark holder. What does this mean? Suppose I am sitting in the Raipur and somebody else is in Rajasthan. I have a business, I'm running a business of selling water bottles with my own brand name, Tripti Bhushan, right? So now what the person sitting in Rajasthan did was that he actually came to know that I am earning a lot of profit by selling my bottles. People are loving my bottles everywhere. People wants, they are asking for my bottles in like whichever shop they are visiting, they're asking the bottle of my brand, right? So what that person has done, he played very clever. He has, you know discovered that the my packaging is very attractive. He has used my logo, TM, like TB, in similar sort of bottles. He has done similar sort of packaging and started selling in entire Rajasthan. So when I came to know that the person is trying to confuse the public, people are getting confused. They are thinking might be I have the same franchise in Rajasthan also, the one who is in Raipur. So if my mark is registered, then I can sue him that there itself. These are the benefit of registering a trademark. Now, what are the essential things that we have discussed in the case of patent, that novelty, inventive step, and utility has to be there? Right. In the same way, for trademark, a trademark should always be very short, unique, and should not contain any sort of scandalous or obscene matter. It should be able to distinguish between what are the goods and services of two people. Even a logo is a trademark because a logo is a symbol or design that is used by a company. Puma. Puma is like as a logo, right? McDonald's. The sign of M is a logo, right? It's unique. Nobody else can have it. The moment you're finding that somebody else is using your logo, you could sue him, right? And in the case like if we'll talk about, there's a case of passing off. What does actually passing off means? Passing off is a similar concept in trademark. It actually means that selling of one's good or services under the trademark that belongs to another. Like I've given you a very simple example. The person X sitting in Rajasthan is selling his goods under my brand name, TB. So that is a concept of passing off. And I'll give you a very simple another example related to passing off. That is like suppose Ram is a manufacturer. He is selling cosmetics under the brand name of Chimpu. Ram is a manufacturer and he is selling cosmetic under the brand name of Chimpu. Now Sham, Sham is his neighbor. He started selling his cosmetics under the brand name of Dimpu. So this amounts to passing off, and Ram have a right to take action against him. Why he can take action against him? Because the two name Chimpu and Dimpu have a similarity. People are likely to get confused. So this is a concept of passing off that one has to take actually care. Now we'll talk about a picture of a flower can be a trademark, but a flower itself cannot be a trademark because it cannot be represented graphically. And now if we'll talk about infringement, we have discussed the concept of passing off. What is a trademark infringement? Trademark infringement is unauthorized use of a trademark or service or in connection with even goods or services in a manner that is likely to cause confusion, deception or mistake. What does deception means? A deception can be a false, creating a confusable image in the mind of public. So if somebody tries to infringe your mark, you have entire right to protect it. You can sue him, you can have damages, right? You have certain remedies provided under the Trademark Act. So the definition of trademark is given under section 2ZB. Now let's see, how do I know that whether I'm infringing the trademark of someone? So in this case, what we will do? In this case, a plaintiff must prove that it owes a valid mark. In the court of law, a plaintiff has to prove that whatever mark he's having for running his business, it is first of all registered and it's a valid mark. That he or she is having high priority on his or mark. But the defendant mark is likely to cause confusion in the minds of consumer. So if the plaintiff has proved that this thing, that the defendant mark is likely to cause confusion in the minds of public, he could get the remedy, he could get the relief. And once if the plaintiff is not able to prove what actually the mark is getting infringed, he won't get any sort of relief. So the plaintiff has to be very clear. He has to establish that he has the priority on his mark, the mark is a valid mark, it has goodwill and it has registered already. Right. Now moving ahead, we'll discuss about what is actually design. What does design mean? Design could be of anything. Basically, design means any sort of feature, shape, configuration, any sort of pattern or combination of color applied to any sort of article. Now, what is article? So don't get confused. Here, the meaning of article is not the article or research writing paper. No. Article means a good, right? So a design could be of a box, a jewelry box. A design could be of a house. Design could be of a copy book. Everything has a design. Whenever we used to go to market, how do we choose a product? The first thing that comes to our mind that our eyes looks at is the design. The most beautiful design we actually picked. Like whenever you're going for a shopping, we picked some of the dresses. Why? The design is beautiful, it's unique. So this is all about design. So design law is actually based on originality, which is not published previously anywhere in the country. So remember that if you have to publish your design, so it should not be published anywhere beforehand, right? And now we'll talk about registration of design. So why registration of design is important? So the registration of design is very important so that the original design, like that I'm creating, that I'm making, suppose I'm creating a design of a jewelry box. So the original design of mine that is created by me is not exploited by somebody else. That's why I need to register my design. Suppose if I have created a very wonderful design working day and night and I have not get it registered. So it's very common that anybody can copy my design and make profit out of it, earn money out of it, right? So registration of design is very important. Now, the duration of registration of design is for 10 years, but it can extend to 5 more years. We have seen in the case of patent, it is for 20 years. In trademark, it is for 10 years. Now, if we'll come to design, so the duration for registration of design is for 10 years, but it can extend to 5 more years. Now, the question comes, whether a design can be registered in respect to which a copyright is expired. So in this case, a registered design, the copyright of which has been expired cannot be re-registered. One thing should be very clear. In this case, already, we cannot re-register a design that is already expired, right? But you can extend it. Now, once your design is registered, same will be notified in the official journal of the patent office, which generally published on every Friday. So, like whenever you have registered your design, you must be thinking, how will I get to know whether my design is published or not? Suppose you're writing an article, so you always are worried, right, whether my article will be published, or if it is published, then on where it is publishing, on which site it is publishing. So in the same way, when the design is registered, same will be notified in the official journal of the patent office, which generally publishes on every Friday. Now, what are the benefits for registering a design? So let's have a look on that. Once a design is registered, it gives the legal right, to bring an action against those person who tries to infringe design, as I have discussed already, in the court of law, not lower than district court, in order to stop such exploitation and to claim damages. So in the IPR, registration plays a very important role, and registration has various sort of benefits, right? We have seen what are the benefits in the case of trademark, benefit in the case of patent. Now we'll see what are the benefits of registering a design under the Design Act. So like once my design is registered, it gives me a legal right. It keeps me at power to bring any sort of action against the person who tries to infringe my design, or who tries to copy my design to make money out of it, right? These are the benefits. Now I will talk about what is the difference between design and a mark. So generally, a design forms a part of any goods or article, right? But mark is applied to goods, like McDonald's. The symbol of M is applied to the McDonald's, right? But the way M is written, it's a design, right? Now, what is the purpose of design? So purpose of design is to enhance aesthetic value of that particular good or article on which it is applied, right? But the purpose of mark is to denote, or to talk about the origin and goods of services. This is all about design. Now we'll talk about what is actually trade secret, right? Trade secret. Trade secret, if you break down the two words, trade plus secret. Trade means commerce, trade activities, right? Secret means something that is very confidential. Now, what is trade secret? It's also a part of IPR. So basically, trade secret are sort of confidential information which has some commercial value, because it's of course a secret, and it should be known only to a limited group of person. If your talks is publicized in the public at large, then no more your talks are secret. And if there is any sort of unauthorized acquisition, right, or use of disclosure of any such secret information in a manner that is contrary to honest commercial practices by other, is regarded as unfair practices and violation of trade secret protection, right? So actually trade secret lasts for 20 years, but further it may therefore continue to last indefinitely as long as the secret is not revealed to public, right? So once whatever you are having conversation between you and the second party in a company, that should be secret, because it already has some sort of commercial value. Once your secret is disclosed in the eyes of public, your secret is no more a secret, and there has to be a trade secret protection, and there's a violation of trade secret protection, right? Now moving ahead, if we talk about what is geographical indication, what is GI? Now, GI means geographical indication. Basically, if we talk about geographical indication, so it is a sign that is used on products, that have specific geographical indication, origin, and it has some sort of reputation due to its origin. Generally, a geographical indication can be used only for agricultural products, or even food stuffs, wine, drinks, or handicrafts, industrial products, etc. Suppose Darjeeling tea of West Bengal. So how do we know Darjeeling tea is from where? It's from West Bengal. So geographical indication tells the origin from which place the concerned product has been originated, right? So this is all about GI. Now we'll see what are the famous, some sort of GIs that has been registered. Now if we look after Jammu and Kashmir, so the Pashmina shawl of Jammu and Kashmir is very famous, right? It has the GI. Now we'll talk about Himachal Pradesh, then the shawl, the Kulu shawl. The painting is very famous. Now if we talk about Sikkim, so the cardamom is very famous in Sikkim. It tells the GI. Assam. In Assam you have Munga silk, Joha rice and Tezpur lychee. I'll repeat my words. In Assam you have Munga silk, Joha rice and Tezpur lychee. Now if we'll talk about West Bengal, you have Darjeeling tea, leather goods. If we'll talk about Bihar, you have Madhubani paintings, Bhagalpuri silk. And if we talk about UP, that is Uttar Pradesh, so you have Lucknow chicken curry craft, you have Desheri mango and Banaras saris. And if we'll talk about Rajasthan, then it's Kathaputis blue pottery of Jaipur. These are some famous stuff that has GI. Right. So this is all about geographical indication. Now moving ahead, we'll talk about copyright. Now what is actually copyright? Copyright is based on the concept of originality and reproduction of the work in any material form. What does actually copyright means? Copyright is a legal means of protecting an author's work. Suppose I am an author, I am writing a novel. So copyright is a legal means of protecting an author's work. That is my work. Many different types of content can be protected by copyright. Like example, books, poem, plays, songs, films, and artwork. Right. Copyright generally lasts for the entire life of a person or plus 60 years. So if we break down the two words, copy plus right. So to avoid third person should not exploit your work or should not copy your work, we can have use of this copyright act, right? We would actually stop the person from doing so. In India, the registration of copyright is not mandatory, as registration is treated as just for the record of fact. But the most important thing is that copyright in any work, whether present in future or past, can only be assigned or licensed in writing by the copyright owner or by his authorized agent. No other person is allowed to license or assign the copyrighted work which is of yours. Only you being the owner has right to assign your copyrighted work. Suppose I have my project. Now it's my choice. I have the only right to give my project to somebody else or to any one of my friend. Because it's my copyrighted work. I have the entire right. It's my choice. Nobody else can do it on my behalf. Right. So in copyright, we'll see there are certain copyright societies. Right. Now, what are actually copyright societies? It is a legal entity which protects the interest of owner of the work in which copyright subsists. Generally, copyright society look after the matters, right? It protects the individual interest of a person in which the copyright subsists. In case of assignment, like assignment and licensing is a part of copyright, we'll deal it further. Now, let's see what is copyright. We have discussed copyright is a right given by the law to the creators of literary, dramatic, musical, artistic work and production of cinematograph, films and sound recordings. Now let's see what is covered by copyright. As I have discussed, there are many different types of content can be protected by copyright. That is books, that comes under literary, literary work, poems, plays, songs, films, dramatic work, sound recording, artistic and musical work. Right. Now, talking about artistic work, we have performers. What are actually performers? Who all are performers? You must be thinking, every artist performs, right? So if we talk about performers' right, section 30 of the Copyright Act talks about performers' right. Now, who all are performers? Even I am a performer today because I am delivering a lecture. So performers are those artists who display their art before audiences. A performer can be a musician, can be a singer, can be an actor, can be a snake charmer, or anyone who delivery even lecture like me I'm doing. So prior to 1994, a performer did not have any sort of protection against the copying of their art, but now they have special rights. Right. So everybody has a right who is performing. Suppose I am going to a live concert and I like a person who is singing a song or who is performing a dance art. So without the permission of that concerned person, if I click the pictures or if I recorded the video, I might get sued in the court of law, because a performer also have a right like an individual person has. So now there's a very famous case that I would like to discuss, that is Super Cassettes Industries Limited versus MySpace. I would repeat my word, that is Super Cassettes Industries Limited versus MySpace Inc. MySpace Inc. Now what happened in this case was that the plaintiff alleged that the defendant has uploaded picture, movies, songs and other material on his website which actually belongs to the plaintiff under a license agreement. So court granted relief to the plaintiff. So what happened in this case was that, suppose everybody nowadays is using YouTube. Now I have my channel on YouTube, right? So now what the next person did was, whatever content I was uploading, on the YouTube of mine, my channel, somebody X, somebody next party, the third party, X party has copied my content and uploaded on his or her channel, right? To confuse people, to make monetary incentive. So now I have right, because these are my copyrighted works, right? Under a license agreement, he cannot be doing so. I can sue him in the court of law, right? Now we'll see what is not covered under copyright. So ideas, fact, recipes, work lacking originality, name, title or short phrases. These things cannot be registered under the Copyright Act. That is not actually covered by copyright. Now we have certain exception, of copyright. What is fair use? Now what does actually fair use means? Fair use means a good use, a good intention. So when it would not amount to copyright. So generally, let us have a look. When the purpose of use is for non-profit educational use, when the nature of copyrighted works allows for the use in the classroom, when the amount and substantially of the portion used is in the relation to the copyrighted work as a whole, when the use does not affect upon the potential market for or value of the copyrighted work. So in general, we mean to say that when, if you are using the copyrighted work of a person or a substantial portion of your copyrighted work of another person for educational purpose, right? For publication in any newspaper or magazine in a form of report, right? Or you are making a maximum of 3 copies for the use of public library, or even publishing or painting, drawing or photographs for architecture or cultural work, that won't amount to copyright. Like, let me give you a very simple example. Suppose X is a researcher, mark my word, X is a research scholar in National Law School, Bangalore, right? So he tries to quote a passage from book of mine. Like, I have my book named by Tripti's Legal Philosophy. I have a book published by the name Tripti Legal Philosophy. Now, listen carefully. Suppose X is a research scholar from National Law School, Bangalore. He quotes a passage from a book of mine into his dissertation with due acknowledging me. Now, what if I file suit against X for infringement? X can actually take defense of fair dealing. Why? Because the person is copying my substantial part of passage, copyrighted work. But also he is acknowledging me for that. So he can take defense of fair dealing if I tries to sue him in the court of law. But what if he is not acknowledging me? Without my prior permission, he is using my entire passage from my copyrighted work, my published novel. So in that case, X won't be having any defense. He cannot take any defense for that. So fair dealing plays a very important role. Now, what is actually the object of copyright? The object of copyright is to encourage authors, composers, artists to create original work by rewarding them with exclusive right for a limited period of time. Right. So this is the object of copyright. So that to encourage the authors, composers and artists who are creating original work, by rewarding them. If I'm creating something and if I'm being rewarded, I would be very motivated, right? I will be self-driven towards to create something new more for the public. So that is my exclusive right. Now let's talk about assignment of copyright. What does actually assignment of copyright means? So assignment of copyright. The owner of copyright or work has a right to assign copyright to any person. Right. Person who assigns is called assigner, and the person to whom rights are assigned is called assign. In the image, you could clearly see that there's a person holding a color palette. Now, he is the assigner. Now, he has a choice to deliver the entire color palette to the person mentioned in the photo. And if he does so, he will be termed as the assigner, and the person will be termed as the assignee. Right. So what happened in assignment? Section 18 talks about assignment in the Copyright Act. So the owner of the copyright can assign the entire copyright, or make only a potential assignment of rights to a person on certain terms and conditions for limited period of time, or for might be the whole term of copyright. So only the person who has the authority can make the assignment. Nobody else can do that. Suppose if I have invited few friends at my home and I have certain amount of work, so I can only delegate that work to somebody else. Nobody else can do on my behalf. That is assignment of copyright, because I am the author, I am the owner of that apartment, that flat, so I have particular right, so I can only delegate that right to somebody else. Nobody else can do that. Right. Now moving ahead, we'll talk about licensing. What does licensing actually mean? See, the term license actually means, some sort of permission, freedom or liberty, right? The license does not actually transfer the ownership, but it actually grants a right to use the license or property. Right. If I am giving license to somebody else, that doesn't mean that you have the entire liberty. I'm not transferring the ownership, but I'm just granting you a right to use the property of mine. Now, licensing is of two types: voluntary licensing and compulsory licensing. So what does the term voluntary licensing mean? Voluntary licensing means out of your free will. If you are doing something out of your free will, free consent, that will be a voluntary licensing. If you are giving permission to use your copyrighted work or even a substantial part of copyrighted work to somebody else, voluntarily, you could not complain at last, because you are doing this voluntary, right? Now, what does compulsory licensing mean? Compulsory licensing helps in spreading of information to the benefit of public at large without compromising the rights of author. Right. Even Berne Convention has made special provisions for the betterment of developing countries. Now there are certain conditions. Let's have a look on certain conditions. The copyright work has not fallen in public domain. The author has refused to republish or allow communication to public. Right. So what happened in this case? What does this compulsory licensing mean? The word compulsory means something mandatory, something forceful. So if you have created something, but it does not fall in the public scenario, right, in public category, and the public is not able to use your work, then the law will even force you to make it available for the use of public. So you have to do this forcefully. In this case, what happened actually? The owner of copyright is forced by law to grant license. The object of enforcing copyright is the promotion of larger public interest. The owner of copyright is forced to even grant license only where his published work is not available to public, as we have discussed, or in the case the author is dead or cannot be found. So in this case, you will be forced to make available your work for the public at large. Now, we have copyright boards also. As we have discussed about copyright societies, now we have a very important term under the act, that is copyright board. Now, what is this copyright board? Copyright board is a quasi-judicial body constituted in September 1958. Now, the jurisdiction of the copyright board extends to the whole of India. The main task of the board is to look after the disputes pertaining to copyright registration, assignment of copyright, or licensing. Now, what happened? I'll take a very simple example. In a university, if a student misbehaves with a faculty, what does a faculty do? He or she has a right to complain it to the higher authorities. Now, higher authorities in a college They have certain boards, they have certain councils to look after all these sort of matters. In the same way, copyright board is also a judicial body that is confined to look after the matters in regard to any sort of disputes that arises in case of copyright registration, assignment of copyright, and licensing. Right? Now we'll be moving ahead. We'll talk about infringement of copyright. What does infringement of copyright actually means? Infringement means violation, copyright violation, right? Copyright infringement or copyright violation is the unauthorized or prohibited use of work covered by the copyright law in the way that violates one of the copyright owner's exclusive right, such as the right to reproduce or perform the copyrighted work or to make derivatives of work. Copyright infringement is like stealing other people's work without getting permission from the original author. Now, I'll give you a very simple example. Suppose I am sitting in the library with my laptop, right? I am doing some very important work, right? I am preparing some like some sort of data codes. I'm generating a software code. Now, with me, I have my friend sitting next to me. I told my friend to please kindly look after my laptop. I'll be back within 5 minutes. I have some very urgent work. So once I left the library, what my friend he or she does was that he tries to copy the entire data without my permission. He tries to copy that data into his pen drive, or he has mailed it. So once when I came back, I came to know that the person has copied the entire material. So what does he has done? He has violated my right because he has made the unauthorized use. So any person who makes the unauthorized use of your work without your permission, that will be termed as copyright infringement. Right. What happened these days? Cyber crimes is increasing day by day. Right. You all know that identity theft, pornography, hacking, spamming, malware. These are all is increasing day by day. So how does this happen? Why does this happen? Because the piracy happens. The violation of right happens. What happened in the case of hacking? If we talk about hacking, a person try to make use of your authorized computer without your prior permission. For hacking, a person does not need to be physically present, right? If I'm sitting at my home, I can easily hack somebody else's computers. By hacking, I will make the unauthorized use of that computer, the data of that particular person. So that would be the violation of the concerned person rights. So that would be termed as infringement. Now, for the case of infringement, a person can sue in the court of law, and there are certain remedies that a person can avail. There has to be a civil remedy, administrative remedy, and criminal remedy, right? So this is all about copyright, and the similar case we have studied in even trademark also. Now I have a very quick recap. I hope you're clear with this. So let's have a quick recap from where we have started. Now one thing is very important. Why legal protection for IPR? Why actually we need to protect our intellectual property right? We need to protect our intellectual property right because economic, social, scientific, and cultural development of society can take place. To encourage the creator of work, it regulates the creation, use, and exploitation of mental or creative labor. It prevents the third parties from becoming unjustly enriched by reaping what they have not sown. The last point is very important. We actually give legal protection that is very important to IPR so that the third person cannot take benefit out of what you have created. For what you have given your best, you have given your hard work, the third person should not enrich it without making a simple effort. Suppose I have made a project for my board exam and my friend tries to copy the entire project of mine, or he gets the photo start and he scored good marks. So what he has done nothing, but he has got good marks because of my project. The entire day and night I am working on my project and somebody else is taking benefit out of my hard work. So in order to stop that, to stop the exploitation of third party for our work, our intellectual property rights need to be protected. Now let's have a very quick recap. We have seen what is IPR today. IPR stands for intellectual property rights. Now we know that human intellect is the only intellect that can create something. Nobody else can do that. No animal can do that, right? Now, what does IPR mean? IPR mean intellectual property right. Basically, is the right that arises from human conduct. Even it's a creation of mind, so we call as intellectual property. We have discussed anything that you make use, that you create by using your mind, by applying your intellect, is your own property, and on that property you have certain right. If you have a house, so that house is yours, it's your property, and you have the all right to protect your house. Property is of two types, we have discussed that: intangible property and physical property. Physical property are those properties which can be felt physically by your hand, with by your senses. By intangible property, we mean that something that we cannot touch, right? Like a person singing a song in the concert, we cannot actually touch the song, but we can actually hear the song. Then we have already discussed what is movable and immovable property. Immovable properties are those property that cannot be moved, like your house. Movable property means, like I am having a book, I can actually keep it to some other place. That is a movable property. And then we have seen what are various types of IPR, like patent, trade secret, trademark, copyright, GI, plant variety, and utility. These are various types of IPR. That's very essential. Then we have discussed why we need legal protection for IPR. We need actually legal protection for IPR, so that to stop third parties from exploiting our own work, to getting unjustly enriched, by reaping what they've actually not sown. People try to take effort of our goodness, of our work. So in order to stop that, in order to get the monetary incentive, to get encouraged, a legal protection must be there for our IPR. Now then we have discussed like brief about various IP rights. Like we have discussed what is patent, trademark, copyright, design, and trade, like GI. So in the case of patent, we know that patent revolves around the concept of novelty, right? An inventive step. And it has to have utility, right? It's a sort of monopoly right that is granted for your invention, right? So the patent is given by whom? National Patent Office. So whenever you're inventing something, so just keep in mind that your invented invention must have some sort of utility in the eyes of public, in the eyes of law. If your invention is not useless for the public at large, then you won't be able to get a patent. And now then we have already discussed that patent lasts for 20 years, right? Then we have studied about trademark. What is trademark? Trademark is based on the concept of distinctiveness and similarities of marks. Trademark is a sort of logo symbol that used to differentiate between the goods of one service from another, right? Then we have discussed about design. What does design mean? Design law is based on the originality, which is not published previously anywhere in the country. So design could be of anything. We have given example of like jewelry box, design of a dress, design of a box, anything. So if you have to publish your design, it should not be published anywhere in the country, right? And the duration of design is 10 years, right? We have done that, and it could be extended to 5 more years. And we have already studied that why registration of design is important. The registration of design is actually important so that, like, if I've created my design of a jewelry box, so it should not be exploited by somebody else. So that we need to have registration of design also. Now, then we have studied the concept of copyright. We know that copyright is based on the concept of originality and reproduction of the work in any material form, right? We should have protection. Then we have talked about the, copyright boards, copyright society. What was a copyright society we discussed? Copyright society is a legal entity, which protects the interest of owner in which the copyright subsists. So every person has a right. So that right has to be protected. That interest has to be protected. So you have certain copyright societies in that case. And in the case of assignment, we have discussed the owner of the copyright only can assign the entire event copyright or make only the potential assignment by certain conditions, by fulfilling certain conditions, and nobody else can do that. Same goes for the case of licensing. The license means giving permission to do something or to not. It's a sort of freedom of liberty that a person has. But we have to be remember that the license does not transfer ownership. It only grants a right to use the licenser's property. Now, in the case of assignment, if we talk about what does assigner or assignee mean? Assigner means somebody who assigns some sort of rights. Assignee means to whom those rights are assigned. This is all about assignment, and actually a copyright lasts for 60 years plus life. Now we have discussed the definition of copyright. Then what does copyright protect? We have seen that it protects, literary work, film, dramatic work, artistic work, or sound right. It's a sort of legal means of protecting any author's work, original work of an author. Many different types of right can be protected. Content can be protected under copyright. That's a book, poem, play, song, films, etc. Now, what does copyright does not cover? That is ideas, facts, recipes, works lacking originality. These things are not covered under copyright. Then we have already studied the exception, that is exception of fair use. Right, what does actually fair use means? When you're using the copyrighted work for educational purpose, or when you're using it for publication, in newspaper, magazine, then it would amount to fair use. Then we have discussed the example of fair use, like that I've given you a very simple example. Suppose like X is a research scholar of National School Bangalore, and he quotes, if he copies a passage from my book, right, for his dissertation or project, with acknowledging me, then what if I file a suit against X for infringement? So X can take defense of fair dealing in this case, because he is giving acknowledgement to me. Without my permission, he is not doing that. But if in case he is not acknowledging me even, then I can sue him in the court of law. Then we have studied the object of copyright. What is the object of copyright? It is to encourage authors, composers, and artists to create original work by even rewarding them. Suppose if I'm working in a company day and night, and I'm working very hard to create what my company wants, but I'm not getting any sort of monetary incentives, any sort of benefit, any sort of encouragement, do you think will I continue in that office? No, I won't continue. So to in case to build the economy, to sustain the growth, to motivate the creator, authors, original workers, we should protect their rights. Right, then we have discussed about assignment of copyright. I will, like, right now I've discussed the owner of copyright work has the right to assign copyright to any other person. Then we have discussed about licensing. What does licensing means? What is compulsory licensing? Right, licensing is of two types: voluntary licensing and compulsory licensing. What happened in the case of compulsory licensing? In compulsory licensing, you are forced to license your work for the public. If your work is not published or fall in the public domain for the use of public, anything if you are making for your own use, for your self-interest, cannot be allowed. Whatever invention or whatever thing you're creating, making, if you're author of the any sort of original work, it has to be followed in the category of public. Right, then we have talked about the infringement of copyright. What does copyright infringement actually means? So we have seen that copyright infringement or copying or violation is the unauthorized uh, or prohibited use of work covered by the copyright law in a way that violates one of the copyright owner's exclusive right. So if somebody tries to violate your privacy, try to violate your right, it is the case of infringement. Or copyright infringement can be also termed as stealing the other people work without getting permission. I can use that simply. This is all about copyright infringement. So let's see what happened. This is all